Welcome to On the Mark. I'm your host, Howard Mark Rubin. I am so excited to present this podcast series addressing our rapidly changing world and how it is affecting industries and people in unique and interesting ways. As John F. Kennedy once said, change is the law of life, and those who look only to the past or present are certain to miss the future. The business leaders and personalities who I will be interviewing in these podcasts certainly look to the future. And I hope you come away with information and inspiration that helps you adapt in both your business and personal lives. You can find these podcasts on all major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, Platzer.com. Welcome to another episode of On the Mark. Today, we're discussing how the estate world has been affected by COVID and AI, and how it's changed the way people practice in that area and how clients are affected in that area. With me today, I have one of my partners who's the head of the estates department at Platzer. Her name is Alison Arden Besunder. Welcome, Alison, to On the Mark.
Thank you. Glad to be here.
So why don't we start off by telling us a little about what you do at Platzer, what's your role and what your practice area is.
Okay. So I joined Goetz, the predecessor, Goetz Fitzpatrick, in 2020, in January 1, 2020, and I joined as the head of the Trust and Estates and Fiduciary Litigation Group. So what our department does, we handle estate planning matters. So on the transactional side, people who need wills and trusts, people who maybe need updates to those wills and trusts as their life goes on, but their documents stay the same. We do estate and trust administration. So when people have existing trusts and they have trustees who need help, we represent the trustees in accountings or decisions that they need to make about beneficiaries. And then on the litigation side, which is where my time is mostly spent, I handle contested guardianships. It's called Article 81. So for adults who need more assistance with their affairs, and also in estate litigation. So will probates, probate contests, siblings fighting, fighting because of second marriages and disputes of that nature.
Now, when you came to the firm, was it pre-COVID, before COVID, or after? It was pre-COVID. Right?
Just before COVID.
Just before COVID, right. That was an interesting time to come into a new business enterprise.
Yes, we all got to know each other real fast.
Yes. So pre-COVID, what was the procedure if someone needed to get estate work done? Did you meet with them in person? Was it just a questionnaire that you emailed to them? What was your procedure before, and how did that change during COVID, if at all?
Good question. So we do have a process so that we can be efficient and spend more of our time with the clients who, as you can imagine, have a lot of emotions that come up. Before COVID, we generally did meet with people in person for an initial consult. And that initial consult, if they're coming into the office, it could generally be an hour, and we would get into a little bit more substance. And sometimes they retained us, sometimes they didn't, but it was generally an hour for that meeting. We had very few clients, or we had a few clients that were international, and we would try to use Skype. And it was very cumbersome, and people didn't really know how to use it. And so video technology was really not common, certainly. And we would have used it, but I think most clients felt like they wanted to have a face-to-face. And after that, we would send questionnaires, we would send asset worksheets, and then we would draft their documents, and they would have to come in for the signing. So the piece of that process for estate planning is that more and more we do those initial consultations by Zoom. And we've been able to, we reduce the time in what those initial consultations are, because some people just really want to get to know what the process is. They want to know what the fees are. And so it has become more efficient in terms of being able to help more clients who need estate planning or want to know about the process. And I think that's true for estate administration and litigation, that we're just able to connect with more people in a more efficient time frame to help them with what their needs are.
See, I would think it's difficult with a client base that I have to think skews towards somewhat older. You're not dealing mostly with 20-year-olds. There are exceptions that you're dealing with younger people, but basically I would think that your client base is a little bit older, and those people have a little bit more problems, just like I do, in dealing with everything virtually. They like to have that that one-to-one contact. I mean, and I would think that in the estates world, as for instance, if you're seeing a divorce lawyer, there's that personal element that you want to. It's not just a question of the competency of the lawyer; it's how you connect with the lawyer, because sometimes you just don't have that connection. And I would think that they'd want to still come in. Do you find that people don't have that need, or do a lot of people still want to come in and to meet you in person?
So, so I will say my charm transcends the video, and so I say tongue in cheek, but I think I'm still able to connect with a lot of people. My business is very referral based, and the flip side of that is there are older people who can't travel as well, and it's inconvenient for them. And so if they have somebody who could help them get on the phone, then sometimes they prefer that. People are always welcome to come in and meet with me. I just find that more and more in the world we live in, the amount of information that's being thrown at us, people being on their computers all day, they prefer not to be traveling and wasting time doing that. But we do have a small subset of clients who are older and would rather meet in person. Very few that we have to go to them. The other, the other piece of it is that as long as we're flexible with doing that, it works. But I would also note that as I get older, my contemporaries, it depends on what you call older, right? My contemporaries are starting to get into the 55 and above crowd. And those are people who grew up in technology. Certainly the generations below me are all about technology, and they prefer even to text, so we have to adapt to that. So the portion of population that you're talking about is
dying out.
Shrinking. Well,
I'm depressed, but it's me.
I'm not saying that they're dying out, but it's not only is it is a large group, but they're also more technically savvy because of COVID, because that's how they were connecting with their kids and their grandkids and reading them books. So I don't find it to be as much of a barrier, and I don't think that people feel like there's not a connection because we had to rely on Zoom during COVID so much. So I think that part changed the culture a lot, significantly.
So I know that wills always were signed in person, estate documents. But now, at least for a lot of documents, contracts, we use DocuSign, or there are other companies who do the same thing as DocuSign, but things is just signed virtually too. Is that true in your practice, that the signatures themselves can be done by a DocuSign type of signature?
So the rule in New York has always been that you have to sign it in person, and there's an execution ceremony, and there is a purpose to that in my practice, certainly, even though it is still the law, because you have had that personal contact. So what you were talking about in terms of the consult, I don't find it to be a difference in terms of the connection or the consult or the communication. And if it is, then we meet in person. But for the signing, they have to be there in person. And I do it the same way every time. That way, if I'm ever asked if there's a deposition, if there's a will contest, I know exactly what we went through. And there's a solemnity to the occasion when somebody comes in and has a tangible piece of paper. There is a bill, I don't know if it passed yet, but there is a bill pending about having electronic will signings. It's going to be one of those things that is optional, not mandatory. I am currently of the view that I will not be doing electronic will signings, just like we've opted out of doing remote notarization.
How about other types of estate documents, such as like a power of attorney? Can that be done virtually?
That's undecided yet, but no, has to be in person.
So,
although I get asked all the time, especially by younger generations, can I just DocuSign it? And there are very good reasons that in my personal opinion, that it should not be a DocuSign type of thing. You don't know who DocuSigned it. You don't know. They're not following the instructions. And even when we've had to send paperwork out to clients to have them sign it on their own in front of witnesses, and we give very specific instructions, 9 times out of 10, it's not followed the right way. So
I know an issue that sometimes comes up is the competency of the testator, the person doing the will. If you have a situation where there may be some question, or someone may question the competency of the person, how do you deal with that? Do you videotape the signing, or is that an attorney-client breach? Do you ask specific questions so that you can then, if you have to testify as to the competency, you can answer it? Do you have more witnesses, less witnesses? How do you deal with a situation when there's a competency potential question?
So, to be pedantic about it, it's capacity, not competency. So testamentary capacity.
See, that's why I'm not an estates lawyer.
Well, it's also, I think there's a layperson's understanding of what the threshold is, and we're not doctors, but we have a
But why don't you
general
tell
sense
us
of what.
what's the standard, what's the stress threshold?
So testamentary capacity is the lowest standard of capacity. You need to know who are the objects of your bounty, meaning the people who would inherit it. You need to know the nature of extent of your assets. Generally, I mean, you don't need to know every penny, pound, and Deutschmark of what it is. You just generally need to be oriented. It is a very hard thing to prove that somebody lacked testamentary capacity, particularly if an attorney supervises the will. So I get a lot of questions of, well, I could go to LegalZoom, but the attorney supervision of a will is a very big imprimatur of approval for the court, right? It's not a guarantee, but it's very hard to overcome. So it's very hard to prove an objection to that. So, but to your question about how do you determine that, it's not a bright line test. I think to a certain extent, it's experience in general as a person and your experience as an attorney. I think a lot of people in the world and in the practice and the media confuse capacity with being able to converse. There are certainly certain situations where you need to, I don't want to say take more care, but you need to go through additional steps. So for example, if I have a blind testator, that doesn't mean they lack capacity. It just means that I am reading the will for them word for word. It's going to take a longer time. It's going to take a longer time in the drafting process to make sure they understand.
Do you video any of this when you have that kind of situation?
I do not. I made a practice determination because of something somebody said in the CLE a long time ago, is that if you're going to videotape one particular signing, why haven't you done it with all the others? It must have been because of your concerns. But my concern is not, I mean, it is, of course, making sure that the person had capacity, because I am signing an affidavit that says that. So how do I determine that? Have I met the person before? Do I know their baseline? If it's a new client, I've met them at the consult. I've met them when we review the documents. I've met them at the signing. I generally ask them pleasantries, right? It's not like they come and we sign them, they're gone. What book are you reading? What are you going to do after you sign the documents? You're going to lunch, right? So yes, the conversation matters because, what is happening? And I'll ask them questions at the signing of general events, right, of what's going on, or I will have asked them that before. And then when I read the affidavit, which says, that I'm attesting and swearing that you're of sound mind, memory, and understanding, not under any pressure, and I ask them if there's any reason that I can't truthfully sign the affidavit. So those are some of the things I go through.
Now, what if the spouse or the child of the testator, they are attested for this testator one to one?
Judge K abolished.
I got that.
Judge K abolished the phrase testatrix or anything ending in IX in 1993, and yet some people still insist on it.
So, say the spouse or the child tells you, my mother or father has been diagnosed with Alzheimer's a year or two ago, and so now you're on notice that the person has that a diagnosed condition. Does that change the way that you would question them or would do the will?
So this is one of my favorite topics at the moment, which is capacity, what capacity is, what the judges and the courts and people understand as capacity. The law is that a diagnosis of Alzheimer's in and of itself is not enough to prove that somebody lacked testamentary capacity, because all you really need is one moment of lucidity. Right? And somebody with dementia, it's not a bright line test. It's not a switch that you turn on and off. And also, I think what people get wrong is the difference between Alzheimer's disease and Alzheimer's dementia and when it progresses. I've spent a lot of time in a lot of cases on this concept and what people get wrong and decision-making capacity. And again, remember, testamentary capacity is the lowest form. Somebody with Alzheimer's can still know, I have assets. You're my father. You're my children. If there's evidence that they're forgetting names, if there's evidence that they can't find their way home, in a will contest, that's going to come out, but it's not going to be the Alzheimer's alone.
Do you ever consult with a person's doctor or medical professional to get their opinion as to their competency or the level of their dementia? Or is that something that you would do? You make that decision. It's not a medical decision.
I generally do not ask for a doctor's opinion. It goes along with the same thing of, I think it's a practice choice, which is, If I went to get a doctor's opinion and I don't do it in the others, well, then why did I do it? Why did I do it there? That's not to say that I would rule it out. It might be something that's done, but I think we're focusing on capacity. I think it's not that it's a bigger issue, but one of the things that is inextricably intertwined with that is there likely to be a will contest? If they're cutting somebody out, then that's a red flag that testamentary capacity or not, I'm taking steps to make sure that this will is going to be protected from a challenge, or we're going to structure it in a different way, or we're having a different kind of a conversation, because that's when it's going to come up to litigation, right? I'm not saying if somebody, even if the will leaves everything to everybody equally and they don't have capacity, we're not signing the will. That that doesn't matter, and that has happened where people wait too long, and it just you just generally know the situations that are going to raise eyebrows of people, and that it just wouldn't be right. So it does happen.
In a situation, I was always taught that you're disinheriting a child. You put in the will that you're intentionally not including this person as someone who's inherited the will. How far does that go? Does that include stepchildren? Maybe that's not a procedure that you follow, that you don't think there's a need to mention a disinherited person in the will. But how important is it to include these people?
Well, a stepchild is not a distributee, which means that they're not somebody that would inherit an intestacy. So if you die without a will, it's either going to go to your spouse and your kids, your parent. There's a statutory hierarchy. Stepchildren are not included. There are some people who do the converse, that they want stepchildren included in the definition of children. And so then that's how we draft. To the larger question of, do you mention the children that you're disinheriting? I think the classic lawyer answer is it depends. I've seen it litigated both ways, that a will, not one that I had drafted, said I'm cutting out my daughter Jane Doe for reasons best known to her.
Right.
And then the argument was, I was never told any reason, so she must have lacked capacity. And then people argue, if you leave them out of the mentioning of that, well, they lack capacity because they didn't know the natural objects of the bounty. So that's how those things wind up going in. Personally, I generally drafted that these are my children and these are who I'm leaving it to, but more often than not, I'm doing some sort of a trust structure to maybe deter what the contest would be.
Do you find that most people do specific bequests? In other words, I always had a feeling that when I have friends in my life, people in my life, and it may not be something of great value, but to them, it was something that maybe some painting that they admired of mine or something like that. And I would make specific bequests. And I've had that happen with me. People have left me things, not of great, financial, value, but, and it was very touching. Do you find a lot of your clients do that? They actually make specific bequests outside of the family to their friends or other people, just as a way to show that they were thought of.
So Howard, is this an initial consult or is it an interview? You asking
No,
for legal
I
advice?
asked
I'm just kidding. I'm keeping it light. So the specific request can be one of cash. That's a cash legacy. So
Right.
sometimes people do that. But I generally find that for personal property, people don't always think about it. But if there is somebody who has a lot of specific requests about personal property, we're generally doing a revocable trust structure where they're saying specifically, I don't like putting that into a will because the wills aren't public, they can be found. And then you're basically saying to people, here's a whole bunch of stuff that's at this vacant house that can be taken. So generally we would do it through a trust, but there are people that do it. I find more often than not that when people who don't have children or stepchildren, they're more inclined to have specific attachment to things that they give to people. Maybe less so when it's children, where they just say it's in a pot, the executor has the discretion to do it. I have people who say, they're going to draw by lots, or they're going to do a snake draft. And we've spent some time doing all sorts of methodology, or some people just say they'll figure it out.
Can you give me, there are, I know there's a lot of different types of trusts. Can you give me the 5-minute version of what type of trust there are that people should consider, and what situations they should consider establishing a trust other than just their will. There's reasons for, sometimes it's because there's minors, sometimes because of there's financial benefits, tax benefits to doing trust. Could you briefly, I don't want to get too technical for the audience of listening to it, but briefly tell me the types of trust that people should be considering depending on their situation in life?
The short answer is no, I can't do it in 5 minutes. The longer answer is, and the answer I give to clients, I think I did a YouTube video on this once, if you dig deep. If you think about trust in terms of there's a revocable trust, meaning it could be revoked, it could be modified, it could be amended. And I look at that as like an alter ego of the person who's doing it. And then there are irrevocable trusts. Irrevocable trusts are like they sound, they're irrevocable, but there are always options for undoing them. It's just harder to do. With a revocable trust, you're not getting asset protection benefits, you're not getting tax benefits. You are essentially avoiding probate, and you can be a little bit more robust in the instructions that you're going to leave about what happens to certain assets. So more and more, I am telling people that they should do a revocable trust because a revocable trust because the court system is overloaded with petitions, and even if there's no contest, it can take a while for them to issue the authority for somebody to go to the bank and get money. And with the trust, there's a little bit more immediacy that you're not missing a beat when the trustee steps in for the most part. And in general, I should give a disclaimer that none of this constitutes legal advice. And so for people who have property out of state, for people who have a lot of personal property, for people who don't have children or a spouse, it's going to minimize the amount of time and documents you need to do in a probate proceeding. So it is a little bit more expensive and it is a little bit more of drafting involved, but at the same time, it's saving your people on the other end when you die from doing that. On an irrevocable trust, there are many, many types of them, but it just depends on what the objective is, tax planning and so on. And there are trusts that can be created in a will. So that's a testamentary trust, which is also irrevocable. How did I do? Was that 5 minutes or less?
That was 5 minutes and less. But what you didn't, I made it a very broad question. I threw a lot in there. But what you didn't address was if you have minor children and you're going to have trusts for the minor children, that's not necessarily for a tax reason. You're going to have people, sometimes it's different people, someone who's going to be the guardian for the children, and maybe someone who's in charge of the finances to take care of the money from the estate. And sometimes it's the same person, sometimes it's a different person. What is a minor? Does a minor mean 5? Could be 30. It depends on the child.
No, it depends on the parent. As far as I'm
Depends on the
concerned,
parent, okay.
as far as I'm concerned, they have to be 40 to get money. But do I get another 5 minutes on the call?
You get another 5 minutes on that.
So it's standard in all of our last will and testaments to have what's called a minor's trust. And what that means is that anybody under the age of, and you can pick your age. I generally have a default of, 20, if they're under 30, it's going to a trust and they get half of the principal at 25, half of the principal at 30, with the ability of the trustee to say, are you problematic? Or are you having an issue where you shouldn't have all this money? And again, it depends on how much money we're talking about in terms of the
Right.
terms of the trust. So that's always in a will, whether or not they have children, because if they say I'm leaving my money to Howard Rubin per Stirpes, that means that if Howard Rubin predeceases me, it's going to your children or grandchildren, and they may be minors. So that's a standard provision we have in all of our wills. People can also set up living trusts for their children, which are sometimes called descendants trusts or minors trust, to which they gift money, and then there's a trustee for that. And this a similar thing. At what age do you want your children to have control over the money? As one of my favorite lecturers, he's a professor at the University of Georgia Law School, always says they call it a trust because it supplies what's missing in the relationship. So it's just a matter of, I think people get hesitant about it, but you're actually protecting people from themselves, from future spouses, from creditors, that if you put it in the trust, it's available to them through the trustee. But that's something to set up. But again, it depends on how much money you're talking about and whether it's economic.
Now, can a testator control their children after death? By, for instance, I know a lawyer. I'm not going to say who this lawyer is, but has children who she wouldn't like them to get tattoos. So can she put in her will that if they get a tattoo, they're disinherited?
Good.
You can do that, and
Good.
that
You
would
know
be,
what?
and that would
That's
be
not in there. That
and that would be enforceable.
That is a good idea. I think I could do that. The only thing that you can make a
Okay,
conditioned
why
on,
can't
you can't make a conditioned on marriage. You can't say you can only marry a Jewish person or you can only marry somebody of the opposite sex. I don't think that would be upheld. That is about to be the main line that you can't cross. But what happens if they get the bequest and then they get the tattoo? That's what the trust is for.
What if you make a condition they can't vote Republican? Can you do that? They promise that if they're found to vote Republican, they get disinherited.
I mean, there's a question of can and should, right? I mean, and how much can you control from the grave? I mean, I'd like to say, as I may tell my own children, like I will come back and haunt you, so you better behave. And I think I've said this fairly publicly that I've told my children, if you fight over the jewelry, it's all going to like UJA. That's not a pledge. I do not promise that, but if you fight over anything, you get absolutely nothing. So, but that's a product of having seen what happens with these families, and that I feel bad when I have these cases. I feel bad for the decedent because I don't think that they would want the legacy to be that their kids are fighting. And that in spending the money on lawyers, it's not how I practice. It's not the philosophy of how I practice. I encourage people to just resolve it because they're going, the mental cost, the emotional cost of being in litigation and fighting, it just isn't worth it. And it's not honoring the parents. But in all seriousness, yes, you can certainly put conditions in there. And that was certainly an old school way of doing it. I think the more modern way of doing it is having conversations with children of like, look, this is the behavior I want to see out of you, and this is why I'm putting it into a trust and all of that. So, I mean, if they're going to go out and get tattoos after you died, then you just
no, but if they got it, if they got it at the time they did it will, and then they got it.
Well, maybe they're going to tattoo a face of my face about something that says like mom, right? And maybe that's permissible.
Put two M's in their butt, and they could spell out mom.
That one's getting clicked out.
Okay.
And
let's talk about another topic. We talked about one of the two great events of the last decade, which was COVID. I'd like to kind of switch to what I consider to be the other great event changer in our time, which is artificial intelligence. It seems to have affected everything in our lives in ways that we never expected, and still in ways we never expected. How has AI affected your practice or your business?
Well, I'm not even really sitting here. This is just an I have actually been watching AI for a long time. And by a long time, I mean, going back to 2016, I went to a presentation at IBM with Watson. And so that's not that long ago. And they were charging a lot of money for use cases that are now just available at your fingertips. How it's changed my practice has yet to be determined because I'm still experimenting with it. I've been trying to educate at the firm by having seminars with people of explaining to them what the limits are. And it's common knowledge and been reported a lot about lawyers who are like, this is great. And they just wholesale have AI writing things, but you wouldn't do that with a live associate, right? You still have to check it. What I find it's really good for are low stakes tasks. So for example, I have an article I want to write. I have all these ideas in paper. Draw me an outline. Make me a schedule of how I could fit this into my schedule and write my book or write my article. I'm trying to think of a way to say this that's not too legalese. Help me. And then there are different applications that I use for different things because they might be better at it. So we have LexisNexis has Protege. That might be good for one task. And then Copilot might be good for another. We're also learning how to prompt. So it's like learning another language, but I'm finding that that's also helping to clarify communication with people, right? Because with the robot, it doesn't know tone. It doesn't know the nuance. And I've written about this. I think there was an article in one of the Bar Association journals called Not Your Mother's Robot about what these applications are. But I think in my practice, again, similar to what happened with COVID, that the implementation of Zoom and video technology helped free up our time to do more meaningful tasks. that's where I'm looking for value add in AI of how can it replace repetitive tasks that without sacrificing the quality so I can spend more time with my clients, which is really what they want. They want my time. They don't necessarily want me staring at a blank piece of paper. And so I think there's a balance that all lawyers need to do, whatever the practice is, of balancing, how to not sacrifice quality and also use that to make it a better mousetrap, so to speak, just like the ATM did with the banks.
Oh, I know in your practice you have several associates who work for you, some paralegals. Do you think that AI is going to make them unnecessary?
Nope.
What is their role going to be that can't be done by AI? Not their role. So if you're the one doing the meeting with the clients and you're doing the part that takes some kind of judgment, and you have, I'm not saying that the associates and paralegals don't use judgment, but they don't use judgment in the same way that given finite tasks, at least from what I see that you give them. Why can't those finite tasks, maybe not today, AI can't do it, but as AI progresses, why can't they take those roles?
A couple of reasons. So I'm going to use e-discovery as an analogy. So in the olden days, associates were in some
Don't call it
warehouse.
the
Like
olden days.
it is
That's
10
my
years
day.
ago. Well, 10 years, the olden days are my days, right? I grew up as a baby associate, and you could be
Right.
in a warehouse just like looking at documents that were 100 years old, right? Now e-discovery has, you do keyword searches and the algorithms have gotten better and better, so it can weed out the unnecessary and allow associates not to be sitting there and making judgment calls on piece by piece, but that there's now a protocol for that. I think the same is true for AI, that if there's a conversation with the paralegals and with the staff and the associates of how to implement it and use it in what you're doing. So for example, if I have a case where I have to do a post-trial memorandum and there's just an enormous amount of information, the AI program or the trial software is much, much better about asking questions of find me all of the citations in the record that support this issue. That's going to be something that I can now do in 5 hours instead of weeks. And it's better for the client and it's better for me because I can spend more time strategizing than project management. Now, I know that there are some people in the profession who say, well, we used to be able to charge X for this. I am more of the mentality that, there are a lot of disputes that don't go forward because of the expense. You're going to have a greater access to justice and also an easier way to resolve disputes when you deploy it. So I know that there's a lot of alarm in the industry about it's going to replace people. And again, I go back to the ATM and, you still have bank employees, and especially in my practice, and even what you said about your clients, they want to be speaking to a human being. You still need the human beings to talk to them. And so the more people I have to talk to clients and have freed up brain space and energy to have those conversations, the more people I can reach now.
But you mentioned banks, for instance, and if I look at banks today, most banks are very small. People don't go to banks; they go to ATMs for most of their functions. That's changing. Your practice is really, there's two parts of your practice. A large part of your practice is a litigation estate-based practice as opposed to the state part of it. And I can understand how you're saying that AI will be a tool to use in the litigation, but in the document preparation part of it, I mean, I can almost see you being able to say to a computer, this is what I need to be done. Do this and this and this and this. This is what the person wants, and that would just take a few minutes for you to after you've got with the client, and they would draft it, and you wouldn't need the associates on the non.
I totally disagree. I mean, I think there are some practice areas where if it is a press the button type of a practice and it's the same complaint over and over, but that's not the practice that I have. And this is exactly what I'm talking about. If you look at tasks and assignments and cases as bandwidths of layers, right, and the process that you go through, I think part of the reason that I am successful in my cases is the written argument. It's one of my favorite things to do. It's one of the best things that I get to do as a lawyer is make a reasoned argument. I am now getting to the point where if I read something, I know it's been generated by AI. It's AI slop, right? And there are times that it actually takes more time to do it through AI because you're editing it and you're going through that. Now, I realize not everybody's like me, right? And that's where lawyers are getting into trouble. I think there are certain tasks that, yes, they're suited to that, and I can accept that, right? A basic complaint that's for like, you just need to hit the elements and the client doesn't want to spend a lot of money. And you have a template that theoretically is, here's a complaint, here are my facts, draft it. Lexis will do that for you. I'm comfortable with that because that is a recognized provider and Lexis does that. You still need somebody to put it in your voice, and AI is never going to replace that. Is it going to take you less time and be a better result for the client? Absolutely. But you're always still going to need that part. It's no different than if you've got a mail merge, right? We've had these technological tools for a long time. This is just one more piece of that puzzle. I think the people who just press a button do that at their own peril and at the risk of their reputation and the type of clients they're going to
So
get.
you think you'll need as much lawyer time, meaning the amount of associates or paralegals in an AI world, than you would without an AI world? It's not going to be a time saver in terms of hours that we need people.
No, because my expectation is that if I do it right, I'm just going to have more clients to service, right? And that need to be spoken to. That's really what it's about.
Well, let me go to another topic that I find interesting in my practice. I want to see if it translates into your. In my practice, I find I'm very frustrated with the court system. I find to get something done. If I want to get to trial, it could take 5 years to get to trial. It could be the amount of discovery that has to be done. It's not only time consuming, it's tremendously expensive. I put into my contracts whenever I can arbitration clauses, mediation clauses, arbitration clauses. Can you put an arbitration clause in a will? That I know there's a provision in a will you can put in that if someone contests the will, they become disinherited. Can you put in a provision in a will or another type of an estate document that says that if there's any dispute, it has to go to mediation or arbitration? Is that something that's doable?
That is an interesting question, Howard. I actually have not thought of that. I don't know that I want to be the test case for it. I think it's possible to put it in. Is it going to be binding? The answer is no. But you can put in certainly.
It's binding in the courts. The courts have a preference for arbitration provisions. There's an arbitration
but you're asking me. But you're asking me in a will. A will is not contract.
Well, you're in surrogate's court. That who's going to make the decision as to whether it's binding? That's going to be a court. It's going to be the surrogate's court.
Right, but I think you're hitting on what the difference is between your role and my role. An arbitration clause in a contract is enforceable because it's a bilateral contract. A will is not a bilateral contract. A will is it's a declaration by the testator of this is what I got, this is where I want to go, and that will give preference. You can put in an expression of wishes, right? And somebody can certainly argue before the surrogate, this testator really didn't want to go to litigation. But if I have that, I'm going to do a trust because a trust is a contract. And so that's more, and I do have that in some provisions. I think in some trusts that I've drafted of like, if you have any challenge, you have to go to a mediator first, right? Or if there's going to do that. So more and more I can do that. In a will, that's a very interesting question about whether that would.
I mean, I am correct, I think, that you can put in your will that if someone contests the will, they become disinherited if they get something. Isn't that true?
Would you like to join my group?
Well,
we have a need for a senior planner.
You know what they say about a little knowledge? That's what I have, a little knowledge. It can be very dangerous.
A little knowledge can be dangerous. So yeah, the answer is yes. You can have a no contest clause in the will without money.
Isn't that the same thing though? Isn't that it's not a bilateral type of thing. And
not the same thing. Now you're getting into the dangerous part.
Right.
It's not the same thing because by statute, they have a right to object. The will is literally probated. The will has to be proven. So there's a presumption that it's valid, but it needs to be proven. And so there is a process, and the surrogate's court is a court of limited jurisdiction. So jurisdiction is very important about getting all the people there and and obviously trying to get beneficiaries their money, which they need, and not holding that up. A no contest clause is different though, because the process is circuit court issues citation and everybody has a chance to come in and say, I object, I don't object. And even if there's a no contest, those people can still take pre-probate discovery. So like pre-answered discovery, so to speak, where it's a little bit different. So you have that right to take that discovery without triggering the no contest clause. Once you file the objections, you either win or don't, and that's what triggers the no contest. So, but the no contest clause is without any money to back it up. Somebody has nothing to lose.
Right. No, they
They're
get
going to
something.
challenge, right? But if you put in $100,000, $500,000, at least, okay, well, am I gonna really risk it given the burden?
So in surrogate court contests, are there jury trials? Do they have jury trials?
Yeah.
And I know from speaking about some of your cases are very contentious. That people, emotional issues and things that come up. It's in the nature of the type of practice that you have. Do you think that that it would be helpful to, in some cases, arbitrate or mediate these disputes? Is there a mediation process, and do you ever ask to arbitrate rather than go through a surrogate court proceeding?
So I have a standard philosophical approach to my practice, which is I try to talk to all potential clients and encourage them to resolve it. And I say to all my adversaries in the beginning, I'm always available to talk to resolve it. The majority of the time, sometimes it's hard, and that depends on who's on the other side and also the clients. So organically, the answer is yes. The court system, the surrogates courts are mediation in surrogates courts has been a very hot topic. Some courts make it not necessarily mandatory, but as a matter of practice, they will send you out to mediation. Others are not so much in favor of it. I personally think that if there was early intervention in the surrogates court, in processing the calendar, which they do to a certain extent with the court attorneys and going out, in some counties, it's just their approach of how they try to do it. That a lot of the process calendar, a lot of the volume would be alleviated. So I think I learned a statistic the other day from one of the counties that there were 9,500 probates that were filed in a year. That's like 35 petitions a day. That doesn't sound like a lot, but it is. It means that the clerks are going through 35 petitions a day to make sure that everything is there, and it's a very specific practice. It's not like Supreme Court and commercial litigation. You file your summons and complaint, there might be a mistake that, no, you need to have all of the things lined up. So
Is it in Supreme Court we have pre-trial hearings and discovery and the processes. Is it any different in a circuit court proceeding than it would be in a Supreme Court proceeding and the case proceeds?
Yes and no. I mean, in circuit court, less so. In guardianship, it's very different how you do discovery because guardianships are petitions. So under the CPLR, you have to have permission under CPLR 408 to take discovery. And so a lot of times you're going to trial and you don't have discovery, and it depends on what the issues are and how intricate and complex it is. So in surrogates court, if it's a probate contest, yes, you would have discovery. You could have pre-objection discovery and post-objection discovery, and then you might get to a trial, jury trial or bench trial. Motions for summary judgment are very common. So it's very rare, I would say, for will contests to get to trial, although I'm about to have one after a decision I just got the other day. And then also there are other applications in surrogates court that would have discovery. So like a turnover proceeding, if I have a decedent and I say, you, Howard, you're in possession of paintings that belong to the decedent, we're going to have a petition about that and have a discovery.
And I know that in your practice, you're appointed receiver by courts.
Not receiver.
Did I say receiver? What?
Again, I am
guardianship.
in guardianship. I'm on the
Guardianship.
Part 36 list. I get appointed in the Article 81 guardianships.
So tell me about when you would get appointed. Why would they appoint? Why would the court appoint someone? What kind of situation is that?
So there's different roles. So in Article 81 guardianships, you're alleging that somebody's incapacitated under the statute. Different standard
Right.
for capacity than in will. And that person needs court-appointed counsel. If they can't hire their own counsel, so the court will appoint that. Sometimes I serve as counsel to the AIP, the alleged incapacitated person. The court also will appoint a court evaluator, which is known as the eyes and ears of the court. And so that's more of an investigatory position where I go out and I get a sense of that person's life, How'd they live before? Do they need a guardian? Are they incapacitated? Do they have a power of attorney and a healthcare proxy? Even if they have it, should somebody independent be appointed? And so I've served in those roles. I do not serve as guardian as a general rule. I've done it once, and it's not something that it's really not something I enjoy doing. And I think there are people who are just better at that role than I am. And then there's a portion where I'm court examiner. And that's when a guardian's appointed. They have to do an annual account. So they have to say, this is the money I took in, this is what I paid out, this is the condition of the ward. And then as court examiner, I have to review those accounts and check them against the bank statements and say, I think that these expenditures should be allowed and others should not. And so that's those roles.
Okay, well, time went pretty fast.
It always does with me.
And that's what I hear.
And you.
Yes, so
we could talk for days.
I want to thank you for being, and I think our listeners got a lot of good information. And I hope to maybe follow up with this later on. And if there's any questions, you can call Alison at Goetz Platzer, and I'm sure she'd be happy to answer your questions. So I want to thank you for being on the mark, and we'll see you next time. Bye.
I hope you enjoyed this episode of On the Mark. I started this podcast by quoting John F. Kennedy and would like to end it with quoting one of my favorite baseball players, Nolan Ryan. Enjoying success requires the ability to adapt. Only by being open to change will you have a true opportunity to get the most from your talent. I wish you success in staying ahead of the curve instead of behind the 8 ball. Thank you for tuning in.